NACDL is the association of the nation's criminal defense bar.
Your best bet in any criminal case, of course, is to win at the trial level, because at that point the burden of proof is working in your favor. But if that doesn't happen, there are several lines of attack you might be able to pursue on appeal. And I'd like to go over some of those lines of attack, and including the statute, the history of the statute, the changes that have been made to it over time, and the cases that have interpreted it, and look at what the elements of the offense are at this point. Talk about some sufficiency and weight arguments, a couple constitutional arguments, maybe even one or two things about pretrial and sentencing issues that might come up. And hopefully this will give you some idea how to handle an appeal if that's what you're doing with regard to a DDRD case, or hopefully also for use at the pretrial and trial stage. Some of these things could be useful there as well. Let's start with the history of the statute and the cases that have interpreted it. It's actually been around a lot longer than I think a lot of people realize. There's obviously been a very recent spike in its use, but it's actually came into effect in 1989. And it has some immediately obvious key features. I'm sorry, that type is pretty tiny. Had to put that on there to get it all on that slide. But subsection A, you'll notice there's no mens rea there at all. It talks about delivering a drug and causation of death, but it doesn't actually say what the applicable mens reas are for that. It also defines drug delivery resulting in death as a form of third-degree murder. And if you're wondering why you would bother to do that when there's a perfectly good third-degree murder statute, I think we've talked a little bit already about how this is kind of a statement statute. It's trotted out based on the notion that it's going to be a useful law enforcement tool to go after these big drug kingpins. And additionally, under subsection B there's a mandatory minimum sentence of 5 years incarceration and a $15,000 fine. Subsection C, though, is where it gets really noteworthy, in my opinion. It's entitled Proof of Sentencing, which is strange, and should put you on notice that something's up with this. And then it talks about proving the applicability of the section, which doesn't make a whole lot of sense if it's a sentencing provision. Subsections D and E are also a little bit odd in that, in my opinion, they're completely superfluous. Subsection D talks about back to the mandatory sentencing. There's no authority to not impose the mandatory sentence, which of course is already obvious from the fact that it's a mandatory minimum. And subsection E includes what I'd call a superfluous right for the Commonwealth to appeal the failure to impose the mandatory minimum sentence. In short, the version of this that comes out in 1989 is a mess. And it doesn't make a whole lot of sense. It's internally contradictory. And despite the fact that it's supposedly a critical law enforcement tool, it actually doesn't get tested by any court in any real way until 1996. And that's in the wonderfully named Commonwealth v. Highhawk case. And in Highhawk, the defendant directly injects the decedent with heroin at the decedent's request. And obviously, the decedent dies. And when she's charged with drug delivery resulting in death, the trial court actually orders the information quashed, saying, this doesn't actually stand on its own. What it is a glorified sentencing enhancement, and unless you add a count of criminal homicide, it has to be dismissed. The Commonwealth appeals, and the Superior Court notes this is the first time anyone's really looked at this statute, and reviews the subsections to look at whether it passes constitutional muster. Looking at subsections A and B, the court says, these are fine. Subsection A says it's a form of third-degree murder, fair enough. Subsection B imposes a mandatory minimum sentence, that's okay too. But confusion occurs once the court gets to subsection C, which I mentioned earlier. Because according to the court, again, referring to proving the applicability of the statute makes no sense if you're already at the sentencing stage. And so what the court ultimately concludes is that it's unconstitutionally vague. It doesn't put people on notice on what it's actually trying to do because of an internal conflict between the subsections, and therefore the statute is tossed. A couple years later, the legislature gets around to putting out an amended version, and here they sensibly remove subsection C from the statute because, again, that's completely incoherent. But it still lacks any kind of explicit mens rea. There's none at all regarding delivery, none at all regarding causation of the death. So it's still got some issues. What it does do, though, it still defines it as a form of third-degree murder, which turns out to be very important. Naturally, this version of the statute is challenged as well. And in two 2004 Pennsylvania Superior Court cases, Nahavandian and Costa, the defendants make basically the same argument, which is that it's unconstitutionally vague because based on the absence of any kind of explicit mens rea, maybe it requires malice, maybe it's a strict liability offense. It's really impossible to tell from the terms of the statute. In both cases, the Superior Court says no, that third-degree murder language there in subsection A is enough to indicate, no, this is a form of homicide, this is a form of murder, therefore malice is required, and the challenges are rejected. The next year, the Supreme Court of Pennsylvania takes a look at the statute too, and confronts pretty much the same issue. This is in Commonwealth v. Ludwig. In Ludwig, a 19-year-old sells a bunch of double-stacked ecstasy to a bunch of younger teenagers, telling them as he sells it, beware of this stuff, it's double-stacked and therefore is especially potent, and be careful. After someone takes it and dies, he's tried and convicted of drug delivery resulting in death. He challenges the statute as unconstitutionally vague, again, for failing to state a specific mens rea and giving no real indication of what it's actually criminalizing. The Commonwealth argues in this case, okay, there's no specific mens rea here, but then you just apply the default culpability provision from section 302, meaning that recklessness would be the default mens rea. But the Supreme Court says, no, that's not right. Based on the third-degree murder language, consistent with the Costa and Nahavandian cases, that means you need malice, and so it's not unconstitutionally vague. However, the court goes on to say that in this particular case, we don't have malice. And there's a bunch of reasons for this. First of all, selling the potentially dangerous drug in and of itself is not enough to get you malice. And it's improper to use one element to establish another. And at this point, the court makes what I consider to be a very important sentence. I'll be getting back to this a little bit later. But it says, using an existing element of the crime to demonstrate a separate element, malice, vitiates malice as an independent element to be proven and renders section 2506 a strict liability crime. Again, I'll be getting back to that, but that's one of the reasons malice isn't present in this case. Additionally, the fact that the defendant doesn't know the tolerance of the user, that doesn't really get you anywhere either because it flips the inquiry from what the defendant knows to what the defendant doesn't know, which is really not an appropriate basis to find malice. Third and fourth, the age of the user and the dosage involved. Well, the defendant's a teenager himself, and he told the people that he sold it to that it was double-stacked ecstasy and therefore especially potent, so it's not exceptionally dangerous what he did in this particular case. And fifth, the fact that a sale is involved, it's not great that there's a pecuniary motive here, but it's not so indicative of hardness of heart as to establish malice on these facts. And so ultimately what the Ludwig court does, it approves the statute, but it says you don't have malice in this particular case. And that's where things stood with the statute until about 6 years later, when really major changes are made. And it gives us almost exactly what we have now as far as where it's at. Most notably, the amended version removes all references to third-degree murder. Instead, the offense is now classified as a first-degree felony with a punishment range of up to 40 years incarceration. That's pretty notable because it's about the same range as you have for third-degree murder, but without that pesky requirement of proving malice, which many DAs at this time were complaining was just too hard to do. And so they had at least something to do with the passage of this amendment because it really opens the door to what we've seen more recently, which is a flood of these prosecutions that are much simpler to accomplish now that you don't have to prove malice. So it seems that that's pretty obviously what they're trying to do here. And it's in contrast to another change in the statute, which is they finally get around to adding a degree of mens rea with regard to the delivery itself. Here they finally add the word intentionally, and so the delivery, whatever form of administering, dispensing, etc., now that has to be accomplished intentionally under this version. And it also removes the mandatory minimum sentence, and along with it, subsections D and E, which were, of course, related to the mandatory minimum sentence. And so at this point, it's leaner, meaner, it's easier to prove, and it still has basically the same sentencing range. In 2014, there's another very slight change made to it. This isn't going to come up a lot, but it makes sure that the 40-year incarceration limit doesn't apply when the victim's under 13 and there's a concurrent prosecution for third-degree murder. This is officially what the text is now. So that's where we're at with the statute in the cases that have interpreted it historically. After initially having no real mens rea at all, now it at least specifies one with regard to the delivery. And it still doesn't have one with regard to causation, but it's clear from the amendments that have occurred in the historical context that the goal is to shed malice as a requirement. Based on the text, we can reach what the elements of the offense are at this stage. And this should be pretty obvious. In fact, you can really just insert numbers here into the statutory text and get at what the elements are. Number 1, intentionally. Number 2, delivering any controlled substance or counterfeit controlled substance. Number 3, in violation of section 113A14 or 30 of the Controlled Substance, Drug Device, and Cosmetic Act. And number 4, another person dies as a result of using the substance. That all seems rather straightforward, and is tracked by the model jury instructions for this offense. The third element, however, has turned out to be a little more controversial than I expected, and I discovered this firsthand in a case that I'm currently litigating in the Pennsylvania Supreme Court, that is Commonwealth v. Peck. And in the Peck case, what happened is the decedent died in Pennsylvania after taking drugs that he bought from the defendant in Maryland. And based on this single Maryland delivery, the Commonwealth charged the defendant, my client, with delivery of a controlled substance and drug delivery resulting in death. But before trial, and in response to a defense motion, the Commonwealth acknowledges there's not really jurisdiction here over this Maryland delivery because it occurred in Maryland. And therefore, we have to dismiss that charge, and we acknowledge that one can't go forward. But at the same time as they do this, the parties agree Section 102 of the Crimes Code, which provides that if one element of an offense occurs in Pennsylvania, there is jurisdiction over the offense. They agree that there is jurisdiction over DDRD because the decedent died in Pennsylvania. So he's tried for DDRD, he's convicted, he's given the maximum sentence, which is ridiculous. I'll talk about that in a minute. But in the post-sentence motion, trial counsel, Josh Niederheiser, pipes up and says, hey, wait a minute. There's no violation of the act here. Because this occurred in Maryland, it cannot possibly have violated Pennsylvania's Controlled Substance, Drug Device, and Cosmetic Act. And the trial court, unfortunately, just kind of shrugs this off, conflates the issue with jurisdiction, says something to the effect of, well, there's jurisdiction here, so what are you talking about? Denies the motion. I took over the case on appeal, raised it as a sufficiency claim, arguing, in my opinion, quite sensibly, a violation of the act is an element of this offense. If the offense occurs outside of Pennsylvania, it doesn't violate the act, therefore you fail to prove an essential element of this offense. I scheduled it for oral argument because I think it's a little bit tricky, and I'm afraid the Superior Court's going to do what the trial court did here too, and that's exactly what happened. They issue a published opinion, I'm sorry everyone, that basically says, well, looking at jurisdiction, there's jurisdiction here, so what are you talking about? There's really no problem. They kind of sidestep the question of whether violation of the act is an official element of the offense. They don't really come out and say it isn't, because that would be completely ridiculous, but they kind of gloss it over and say there's no problem, affirmed. I petitioned for re-argument en banc, that went nowhere, and petitioned for allowance of appeal. And just recently, the Supreme Court granted allowance of appeal over 3 issues. I tried to break it into 3 parts to avoid this pesky jurisdiction thing in the hopes of establishing that the violation of the act is an element of the offense, a delivery occurring in another state doesn't violate the act, and therefore you have a sufficiency of the evidence problem in a case like this where the delivery occurs in Maryland. I feel pretty confident that they'll at least agree with the first argument, because I don't think there's any getting around that statutory text. And it would also be silly to have convictions with no violation of the act, because then I think you're going to get in it's at least theoretically possible that med mal cases could potentially result in DDRD convictions. This would be pretty extreme, but even dispensing a prescription through a pharmacist could theoretically at least get to a DDRD conviction. So I feel fairly confident that after the Peck case is decided, at a minimum, it'll be clear that that's an element of the offense, violation of the act. The rest of it, maybe less so, but we'll see how that goes. Based on all of this, there's a lot of strategies that become apparent, both on appeal and at the pretrial and trial stage. I just want to have a quick note on pretrial issues. I think that others are going to get into this much more in depth later, but I think that I'm sure many of us have seen that in these cases, text messages are extraordinarily important, because unfortunately our clients tend to document forensically the deals that they make with people. In the Peck case in particular, I have text messages from the decedent saying, "Hey, thanks for the heroin, essentially, that you just gave me. I'm about to take it now. I have now taken it. It's great, and thank you very much." And so, obviously, if you're able to get at those, that's a very useful strategy. And there's really two lines of attack here: Fourth Amendment and rules of evidence. If you're going Fourth Amendment route, which is likely to be the most successful in a lot of cases, I just can't recommend enough that everyone in this room read Commonwealth v. Fulton. It's a 2018 Pennsylvania Supreme Court case. It's a fairly straightforward application of Riley and Worry, the United States Supreme Court case, but it adds some useful language on what constitutes a search in this context, and it's a useful playbook for how to handle text issues pre-trial. Commonwealth v. Koch is useful if you're going for rules of evidence. Authentication and hearsay tend to be the main issues here. There's a Supreme Court version of Koch that actually affirmed it by an equally divided court that's not as useful. So I look at the Superior Court version of Koch. I think it's a very useful case, both in explaining what the issues are when you're talking about evidentiary concerns here, and in saying what is useful for a challenge. Let's talk about constitutional attacks. Obviously, vagueness has been a big deal with this statute since its inception, and people are continuing to try to challenge this as unconstitutionally vague for fairly obvious reasons in light of the mens rea issues. Unfortunately, it hasn't gone so well. The three key cases, at least currently on vagueness with regard to the statute, are Cockencam, that's how I'm pronouncing it, Proctor, and Story, and all of them have gone badly, but let's go through them. In Cockencam, the defendant sells heroin to the decedent, gets charged with DDRD and convicted, of course, argues on appeal that the statute is still unconstitutionally vague because it fails to indicate what the mens rea is with regard to causation. The Superior Court disagrees, noting there are really two principal elements of this offense: the delivery of the drug, obviously, and the causation of the death. And it notes helpfully that, well, the delivery, everyone understands that because that says it needs to be intentionally. With regard to causation, ultimately the court comes down and says causation in the criminal sense is understood in the criminal code, and it comes from section 303 of the crimes code, which indicates that what you need there is but for causation. In other words, if not for the delivery of the drug, the person wouldn't have died. And so there's no vagueness problem here because that's obvious to everyone. Now, it adds that the death can't be so extraordinarily remote from the delivery of the drug that attaching criminal liability would be fundamentally unfair. It doesn't really define what that means, but it says that as a general rule, and particularly in this case, you're right in the wheelhouse of what was intended to be criminalized by the statute, and you can't say that it's unconstitutionally vague as applied to you. It rejected the notion that it's a strict liability offense, however, finding that even though there's no mens rea with regard to causation, that doesn't mean it's strict liability. That means in this particular instance, you need recklessness under section 302C of the crimes code. And so as long as you're reckless in what you did, then finding the causation is proper. And then it goes on to find recklessness in this particular case from the fact that you sold heroin. That's important. I'll be getting back to that in a couple minutes too. But that is basically cock and cam, which has a pretty detailed consideration of the vagueness issue and a comprehensive rejection of it. Proctor is more or less the same. The slight wrinkle in the Proctor case is that there were other drugs in the decedent's system, which enabled the argument that we don't really know whether this drug in particular is what caused the decedent's death. But the court is not convinced by that. The court notes there was a, quote, lethal dose of heroin in the decedent's system, and that's enough. It's enough to show that it's a substantial contributing factor to the death, and which to me is a little loosey-goosey. It's not quite the same thing as but-for causation, but according to the Proctor court, good enough. Story is a little bit different. Story is, the distinguishing feature in Story is that the person that the defendant sold drugs to turns around, sells them to a third person, and it's the third person who actually dies. And so the defendant, quite understandably, makes a big deal about this on appeal and says, I didn't even know about this third person. It's completely ridiculous for me to be charged with conduct that results in the death of the third person. The statute's unconstitutionally vague as applied to me. Superior Court says, too bad. That's not true. That another person language in the statute evinces a clear intent to have a pretty broad application, and you do fall under that, and therefore your conviction is affirmed. Now, these cases obviously don't bode well for further attempts to challenge this on vagueness grounds, but it's worth noting that the Supreme Court of Pennsylvania hasn't weighed in on these challenges yet. Denied appeal in all three of these cases very recently in Story. And so if you do have a challenge like this bouncing around, you're probably not going to get relief at the trial court or even Superior Court level at this stage, but you could at least hold out for Supreme Court relief and say that these cases were wrongly decided and you need to decide this issue. But obviously, these cases are not good news for that kind of argument. There's also maybe room for a challenge if the death is really severely attenuated from the delivery. That would give you a chance to deploy that extraordinarily remote language that is included in the cock and cam case. Because the way it's drafted, you could theoretically have a prosecution for 5, 6, 7, 8, any number of steps removed. If you can say, but for A giving the drugs to B, person X would never have died. Which is actually one of the things that's sort of ironic about this statute. Obviously, there's already been some discussion about how it's supposedly a useful tool against drug kingpins, but it's the drug kingpins who would actually have the best luck in challenging the application of the statute to them, because they can say, you're getting so far removed from what I did when I gave it to my distributor that to apply it to me is so extraordinarily remote that it would be fundamentally unfair. But obviously, most of us are not dealing with kingpins. You're going to have the vast majority of these cases at most 1 or 2 steps removed from the death. Maybe a better challenge, one that I haven't seen yet, this is that language from Ludwig that I mentioned. It's sort of hinted at by this language. The sentence I highlighted once again, using an existing element of the crime to demonstrate a separate element, malice, vitiates malice as an independent element to be proven and renders Section 2506 a strict liability crime. This, as I'm sure many of you have seen, is exactly what the Commonwealth has been doing in a large number of cases. All they have to say to establish, recklessness is the fact that the defendant sold a dangerous drug in the first place. Now, under this language in Ludwig, I think an argument could be made, well, you're turning this into a strict liability crime then, because in those particular cases, as applied to those particular defendants, what you're doing is you're taking one element and using it to prove another. And under this Ludwig case, that's improper, and as applied to these clients, it's unconstitutionally vague because it's not clear what the statute is prohibiting. Like I said, I haven't seen this yet. I don't know how receptive courts would be to it based on almost every case I've seen so far, probably not very, but I think it is something that could come up. And in all these cases where the Commonwealth has nothing to say apart from you dealt drugs to establish the supposedly, culpable conduct on your client's part, it is a statute that might be worth making. There may also be some sufficiency and weight arguments to be made. Obviously, I'm talking about on appeal. In some cases, you might be talking more about a habeas corpus motion at the trial level. Sufficiency, of course, is going to depend on the different elements. You're not going to have a whole lot based on whether the delivery was intentional. There aren't that many accidental deliveries out there. And I haven't seen a whole lot of them. You probably won't have too many where the identity of who made the delivery is in question, especially because most of these cases, the defendants have documented everything on their cell phone. But another challenge, like in the Peck case, could be that the delivery, for whatever reason, did not violate the act. The geographical restriction is probably the most useful one in this regard, in that it's probably the cleanest and most obvious basis for saying there was no violation of the act. But if you have a client or if you have a case where for some reason the delivery itself did not actually technically violate the act, that would be a useful argument to make. In most cases, however, these arguments are really going to center on causation. I'm not going to get too much into causation. I think Andrea is going to talk about that, and I think others are going to talk about it too. But certainly in a lot of these cases, we're dealing with decedents who have a lot of drugs in their system. They're poly users. In a lot of cases, sure, there's a lethal dose, but is it what actually caused the death? That's an argument that may be available in numerous cases like this on appeal. As for weight, it's typically so hopeless that it's probably not even worth the mention, but let's go through it real quick. The phrase that's often used is when the figure of justice totters on her pedestal, or when the jury's verdict at the time of its rendition causes the trial judge to lose his breath temporarily and causes him to almost fall from the bench, then it is truly shocking to the judicial conscience. So if you have a case where a supernatural event occurs and the wrongful verdict is rendered, you may have a viable weight claim. It doesn't stop us from raising it. Sometimes that's all you've got. And the causation area in particular is a potentially fruitful ground for this, given that sometimes you will have a lot of different drugs in the decedent's system. But obviously, I think we all know that weight doesn't really ever succeed. A couple things about sentencing. I don't have a whole lot to say about this that's specific to DDRD, but because it came up in the Peck case, I think it's worth noting. In that case, the court imposed the maximum sentence for what I would consider to be a completely garden variety DDRD. But when it did so, it made a bunch of dramatic statements at sentencing relying on factors that are plainly part of the offense. It said, "You, sir, are a peddler of poison, and a young man died as a result of your actions," both of which are obviously inherent in every single DDRD because you've got a delivery of drugs and you've got the death of another human being. It didn't stop the court from saying this is a reason to impose a maximum sentence, but this is worth noting because you can challenge this either when it's happening or on appeal. The court also relied on the defendant's prior record score as a reason for imposing a greater sentence, which again is inherent in the sentencing guidelines and is not a proper basis for a bigger sentence. The key cases on this are Goggins and Johnson, which Goggins talks more generally about double counting factors that are already included. Johnson is more specific to prior record score, but they both say essentially the same thing. Unfortunately, now, if anyone's dealing with this issue, you'll have to deal with my Peck case, and I'm sorry for that, because Peck says essentially the court wasn't really relying on the prior convictions per se. The court was relying on the fact that the prior convictions reflected poor rehabilitative potential, which to me is ludicrous because that is why prior convictions are in the guidelines to begin with. They reflect a poor rehabilitative potential, and that's why they're part of every single sentence from the get-go. But again, it's out there. I'm sorry. Goggins and Johnson, in my opinion, are much better reasoned, and you can use them certainly to make this argument if you have a trial court that relies on factors inherent in the offense or the prior record score. Ludwig, again, may be helpful here because, as I noted earlier, it cites a litany of facts that supposedly warranted a finding of malice. Obviously, at sentencing, we're not concerned with malice per se, but it does knock down these factors and explain why they don't really establish anything particularly egregious about a DDRD. And so you may want to look at that case for those purposes too. There's my contact information. I'm happy to talk about any of these issues if anyone ever wants to reach out to me. I'm an appellate lawyer, so I dork out about this stuff. If anyone wants to brainstorm any of these issues, feel free to contact me. Thanks.